In 1898 Nebraska, the rigid rules of traditional common law dictated that a promise to give a gift carried no legal weight. John C. Ricketts handed his granddaughter, Katie Scothorn, a promissory note for $2,000, specifically so she could quit her job as a bookkeeper. Relying on that paper, she immediately abandoned her occupation. When the estate's executor refused to pay, the law hit a structural deadlock. The grandfather's note failed the core test of a formal contract: consideration. He sought nothing in exchange and exacted no formal bargain. The court recognized the injustice of leaving Scothorn empty-handed. To reach a different outcome, they needed a mechanism to bypass the rigid requirement of a bargained-for exchange. They utilized the concept of equitable estoppel. Because Scothorn intentionally worsened her financial position by relying on the note, the court ruled the executor could not raise the defense of a lack of consideration. This ruling introduced a potential bypass to the requirement of bargain, providing a new template for future judges to address similar cases of perceived injustice. By 1932, scholars formally codified this reliance principle in Section 90 of the Restatement of Contracts. Decades later, the drafters of the second restatement expanded its scope. They removed strict limitations on how definite reliance must be and explicitly endorsed its application in commercial contexts. This expansion triggered a sweeping academic consensus. Prominent legal scholars like Grant Gilmore and P.S. Ataya concluded that traditional contract law was effectively over. The theory held that the tort-based principle of reliance, protecting people from harm when a promise is broken, would eventually swallow the consent-based rules of bargained-for exchange. This became the accepted reality taught to generations of law students. Promissory estoppel had become a primary, independent theory of legal obligation. Yet modern empirical data reveals a different story. The death of contract never actually happened. A comprehensive empirical study published in the Cornell Law Review examined all reported state court cases between 1981 and 1992 to test the actual viability of Section 90 in practice. Nationally, out of thousands of litigated contract disputes over a decade, there were exactly 28 successful promissory estoppel claims. Isolating New York, out of 34 total claims, judges handed down 29 outright dismissals. California courts produced similar outcomes, rejecting 10 out of 13 claims. To understand this failure rate, we have to look at judicial filtering. Appellate and trial courts use specific mechanics to protect traditional contract principles and block equitable claims. Courts are actively and systematically starving the reliance principle of oxygen. The first filter is the rigid demand for a clear and definite promise. The text of Restatement Section 90 broadly requires only a promise to trigger liability. In practice, judges require the promise to meet the stringent standards of a formal contract offer. Commercial property cases like Messina v. Bitterman show this filter in action. Developers claimed they had a written commitment from the city to submit property plans. The court neutralized the reliance claim by classifying the city's commitment as an agreement to negotiate rather than a binding promise. By pointing out the lack of specific material terms, judges easily classify these promises as too ambiguous to justify legal reliance. By forcing promises to meet the exacting standards of a traditional contract, judges effectively block the equitable flexibility that Section 90 was built to provide. The second filter is the demand that a plaintiff's reliance be both definite and substantial. The drafters of the second restatement explicitly removed the definite and substantial requirement. Courts stubbornly refused to drop it. Judges demand absolute but-for causality. Plaintiffs must prove they would not have acted if the promise was never made. Take Smith v. City of San Francisco. The city promised to give fair consideration to a developer's applications, encouraging them to submit proposals. The court rejected the claim for costly plan preparation. The developers would have had to pay for those architectural blueprints regardless of the city's promise. Courts use this causality standard so plaintiffs cannot use general business expenses as a backdoor to liability. The third and most insurmountable filter is overwhelming judicial deference to the statute of frauds, the rule requiring certain contracts to be in writing. Section 139 was designed to allow promissory estoppel to bypass the lack of a written contract. Courts largely ignore it. In employment cases like Cunnison and Ginsburg, employees relocated and rejected other job offers based on unwritten promises of multi-year employment, only to be fired shortly after. The courts applied a ruthless calculus. Losing your job and moving across the country is not egregious enough to defeat the formal rightum requirement. Courts will only bypass the statute of frauds in cases of severe unjust enrichment. They prioritize preventing a promissor from profiting unfairly over protecting a promisee from suffering harm. Why do modern appellate and trial judges work so hard to defeat Section 90 and defy the academic consensus? Judges inherently distrust unwritten, unbargained for claims. They are institutionally wired to defend the mechanics of the formal bargain. The strict requirements of consideration and written documentation serve vital evidentiary, cautionary, and channeling functions in the legal system. These formal rules force both parties into a circumspective frame of mind, providing judges with proof of an actual intent to be legally bound. Even in the rare instances where courts do enforce a reliance claim, they actively search the facts for an implied-in-fact contract first. They prefer to find a hidden bargain rather than rely on pure equity. Modern judges use reliance as a diagnostic tool to confirm that a traditional, intended contract exists beneath the surface of a dispute. There is a stark dichotomy between the academic theory taught in law schools and the judicial reality practiced in courts. The legal machinery always defaults back to its origins. Litigators today find Promissory Estoppel to be a tightly controlled, inferior doctrine of last resort, a departure from the omnipotent theory academic scholars predicted. It remains a secondary tool used to patch the rarest of injustices, rather than a replacement for the core rules of contract. The death of contract was greatly exaggerated. The bargained-for exchange continues to define the boundaries of contractual liability, surviving the theoretical challenges that attempted to replace it.